name's Christine Link. I'm the Executive Director of the Ohio ACLU. I'm not sure this is on. Does it make a difference? To start, most of you are probably aware that we have two physical offices, one in Cleveland where I'm based, along with Carrie Davis, our staff counsel, and Mike Brickner, our media director. And we also have a physical office now here in Columbus, which is relatively new, headed up by Gary Daniels, our associate director, with our field organizer Morgan Patton, who's personing the TV cameras. Our TV cameras are here so that later on we can use the presentation as a podcast off the ACLU website. We decided to hold a little press briefing with the kickoff of the new school year because every year presents a range of challenges to civil liberties as kids come back to the classroom and administrators try to figure out how to deal with these new challenges to keeping order in the school, keeping school productive, and at the same time respecting basic rights and freedoms for their students. It's a complex and often confusing area of law, and Carrie and our staff can tell you that we hear from an awful lot of parents and students and an awful lot of school systems at this time of the year. So to kind of get started on a less confrontational foot with the school systems and a more collaborative one, ACLU of Ohio issued a letter that was directed at school superintendents focusing primarily on the issues of new technology and civil liberties, giving them some guidelines as to where we see the balance between the rights of individual students and the duty of the school to educate and also maintain a fair degree of control over the school system. We brought together 3 panelists in addition to our staff to kind of give you some information and some perspective. Each one will talk for just a few minutes so that we can have a lot of time for exchange and comment. The first speaker will be Brian Laliberte, who is a volunteer with the ACLU and an attorney in private practice. The next speaker is Colleen Cunningham, who is a public high school teacher, teaches business and theater, cover the whole spectrum of kids' interests. Speaking as cleanup is Carrie Davis, their staff counsel, most of you know. So I'll sit down and let those 3 people take over, and then after their few minutes we'll have questions.
I'd like to talk just a little bit about each of the 2 topics we're addressing here this morning, sexting and student online speech. As you know, sexting is generally defined as the use of cell phone text messages, electronic mail, online resources such as websites, MySpace, Facebook, and other blogs to transmit nude or semi-nude photos of underage individuals. The criminal laws, both state and federal, punish the transmission or possession of child pornography, which, of course, a nude or semi-nude photo of a person under age 18 could be considered. Sexting has been occurring among teenagers of all ages, and there are at least some reported cases of children as young as 10 or 11 participating in it. And it has subjected teenagers to criminal charges as both juveniles and as adults, that in some cases have resulted in serious penalties. We all know that under Adam Walsh and under other state sex offender laws, if you're convicted of a child pornography offense or a sex offense more broadly, you may be required to register as a sex offender for a very long period of time, and in the worst cases you might be required to register for life. Those types of registrations carry all sorts of other conditions with them, including prohibitions from going on school property, holding certain types of jobs, and like that. As a former prosecutor and as someone who was involved in passing the Adam Walsh law here in the state of Ohio, I really don't believe that sex offender laws and sex crimes laws and certainly child pornography laws were intended to criminalize and punish what could be considered and what I think is somewhat typical adolescent behavior, only using very modern means of communication. And because that means of communication allows these kids to transmit photographs over state lines very easily or to one another very easily, just doesn't mean that it's necessarily the kind of conduct that sex crimes laws or child pornography laws were intended to punish. So my humble opinion is that school officials, police, and prosecutors who become aware of sexting in their districts really need to use good judgment and assess whether the conduct that's occurring is trafficking in explicit underage sexual photographs or simple adolescent behavior that is better addressed through counseling and instruction and not punishment. Consequently, the adults who are involved in these types of cases really need to take responsibility for assessing the facts and making sure that those involved, those children involved, are treated appropriately and rationally, considering all the circumstances. The second area that we're here to talk about this morning is student online speech, which, as the son of a 35-year veteran of Ohio's public schools, I have a particular interest in, only because my mother was a particularly hard math teacher to have in high school, and she was certainly subject to lots of taunts and barbs from students over the years, and she has an incredibly thick skin, and I think she has a very healthy respect for the First Amendment rights students possess once they're outside the school grounds, because she's heard more than once how terrible a person and teacher she is, which she of course isn't. But you know, I think it raises an interesting question. You know, she has a very thick skin. Some teachers don't, and so you know the question always comes: what can teachers, what can school districts do when their staff are subject to speech that may not necessarily be very friendly, and in fact might be very offensive. And again, you know, what a student does on his or her own time in the context of speech isn't something that the school can touch under the First Amendment. What the school can do is regulate reasonably speech that occurs on school property and with school resources. And so, again, I think it requires a great deal of judgment and discretion on the part of school officials and teachers and parents to understand that students are going to exercise their First Amendment rights outside of school, and to engage with them in an instructional way and not in a confrontational way that tries to deprive them of their constitutional rights.